based on an international conference that was held in Erie, Pennsylvania in September. During that conference, we had two individuals. They were world-renowned patent attorneys from Europe who came to Erie and to the gentleman came to Erie, Pennsylvania, to give this presentation in a slightly modified form, and it was a joint presentation. Unfortunately, the gentlemen aren't able to join us today, but they did send their greetings to everyone here, both in New Haven and those of you watching via simulcast. Can we back up one slide, actually? Back up, all the way to slide one. There we go. Okay. The title of this presentation is Intellectual Property and Patent Law Doing Business Globally. And I want to emphasize that we're going to be looking at the advantages of internationalism. And one of the things I really noted from Yvonne's introduction is that there were several questions, several subjects that we're going to be discussing, but a lot of those questions and some of those discussions can be answered with one word: yes. Why? Because internationalism is inherent in intellectual property. Intellectual property is inherent in internationalism. And intellectual property represents an area that oh, I'm sorry. Great. We'll start out with some shameless self-promotion here. I'm going to tell you a little bit about myself and about my colleagues who team taught the presentation, probably to feed my own ego a little bit, but more importantly, to give you all an idea of what perspective I'm approaching this from, so you can see why it is we're using intellectual property as an example of internationalization. My firm, Woodard International Law, we're headquartered in Erie, Pennsylvania. We're a national international law firm focusing on the protection of technology and business interests. We have offices in Erie and in Cincinnati. The slides don't reflect that we're also working on a third office in the Lehigh Valley in eastern Pennsylvania, near the New Jersey border, just north of Philadelphia. There's our contact information. Now, some of these slides were also prepared by one of our colleague law firms, a deal and partner firm of Munich, Germany. They're located in Munich. They were founded in 1972. One of the things that most patent attorneys don't even realize, and certainly most of the general public don't realize, is that in Europe, unlike in the US, where attorneys of law and patent attorneys are kind of more often than not are single individuals all wrapped up into one, in Europe, there are two completely different sets. It's very unusual for there to be both, for an individual to be both a patent attorney and an attorney at law. They're two completely different educational routes, unlike in the U.S. And as a result, it's very likely that any one individual will have both credentials. Now, the deal and partner firm has both attorneys. I just want to acknowledge them for their contribution. And we'll start with the general proposition: why international? Now, I'm assuming everyone at the conference has an international mindset. We wouldn't be here. A lot of this presentation was originally aimed at an audience in the Rust Belt region of the U.S., where there's a lot of skepticism about internationalization and a lot of damage to the economy from internationalization. So it's kind of an uphill battle trying to convince individuals why they need to go international. But I think a lot of the lessons that we're going to be discussing are really universal, and I think they really apply to this audience as well. So I'm going to just pose the question: why international? And I'm going to use the international legal arena as an example. So to do this, we'll start out with a quick hypothetical situation and maybe a little survey. Okay. I'm just going to go off the slides. Imagine you have a new product and you want to market it around the world. Now imagine you've also secured patents and you've registered your product trademark in every country where there's a significant demand, or at least a perceived demand, of your product. So let's say, just for discussion, the countries you're looking at, in addition to the United States, are China, and then the several countries of the European Patent Organization. Okay, now, imagine another company openly begins to sell a patent infringing product using your registered trademark. This is very important. We're talking about both patents and trademarks. There's a company overseas that is, or even, would you rather try to enforce your patent and trademark rights in the U.S., in China, or in Europe? So I'm going to take this. I'm going to just take a quick, for those of a quick survey for those of us here in New Haven. Who would? Is there anyone here who would rather enforce in China? Anybody want to raise their hand? Is there anybody here who would rather enforce in Europe? Okay, we have one person, one raised hand. Is there anyone in here who'd rather enforce in the U.S.? Got several more hands. Okay. Surprise. I'm going to challenge you with the idea that perhaps everyone in this room should have raised their hand for Europe or China. When enforcing patent and trademark rights, China and Europe are likely cheaper, easier, and most importantly, more likely to get you quicker results. Now, this is going to be a hard sell. I'm going to tell you, when I gave the first version of this presentation in Erie last month, we had an individual, a graduate of this university, in fact, who was sitting in the very front row of a large auditorium, shaking his head when we got to this slide, saying, no, it's not, no, it's not. This is an individual who had a company that had done a good deal of intellectual property, not with myself, but I was aware of the work they were doing. Not necessarily a lot of international intellectual property, but I'm sure if you asked this individual, he would have described himself as a battle-hardened intellectual property owner. So I realize this is a hard sell. So the only thing I can really do is show. Enforcement actions in China are surprisingly lightning fast. Enforcement periods in China normally only last a few months. We'll say 6 months to a few years, maybe 1 year, 2 years, rarely longer. Okay, I have some sources for that. Now let's compare to the U.S. In the U.S., 5, 10, 15 years more. A couple of years ago, I used to sit on a trade task advisory committee for a U.S. congressman, and we had one year some individuals from the U.S. Consulate in China come to visit us during one of our meetings. And during that meeting, the gentleman from the consulate made the point that one of the problems in China, it was not so much that they couldn't enforce, but that it could take 2 years to get enforcement actions. Now, there was another lawyer who sat on the board with me from another firm, and he and I both started chuckling. We looked at each other and started chuckling together. The congressman looked at both of us and said, gentlemen, would you like to add something? And my colleague, he gave the floor to me, and I looked at the congressman and I said, Congressman, if we could enforce intellectual property rights in the U.S. in 2 years, we'd like to be the richest law firm in the United States. Enforcement actions in the federal system take a long time. So if they're able to enforce in China in up to 2 years, that's telling you something. There are high rates of successful enforcement. As early as 2010, the average rate of successful IP enforcement in China by U.S. IP owners varied, and this is by Chinese province, from approximately 66 to 99%, with success rates apparently increasing.
And what was that one in the U.S.?
I'm sorry?
That number in the U.S. was
Right. Back here. Now this number actually is in China.
Yeah, but what was the U.S. entire?
Oh, I don't have the rates, but it's probably numbers probably not that high. Almost certainly not that high. But we'll get to some questions and answers at the end. Okay, now some other things about China. The first question I get when I proposed to one of my clients, hey, we have to really get protection in China for this as well, the first question they have is, well, how am I ever going to enforce it there? Well, I'll tell you, enforcement is much less expensive than it is in the U.S. I mean, you're looking at possibly a couple of thousands or tens of thousands of dollars. Now, keep in mind, you're going to see some of these numbers compared to some of the other statistics that my colleagues came up with. Don't get too bogged down in the numbers at this point. The whole idea here is I'm trying to give everyone a flavor of the kind of numbers we're going to run into. You'll see that the statistics kind of start to match out when you get to the larger numbers and you look at the shifts and the orders of magnitude. We were actually surprised when I spoke to my colleagues about this. We were surprised how close our numbers came because we were coming from different statistical sources. But the point to take from this is you're spending maybe a few thousands or tens of thousands of dollars. In the U.S., maybe $2, $5 million more, and those are probably minimum numbers. Okay, so very high rates of enforcement. Surprisingly effective enforcement. Options for both severe civil and criminal penalties enforcement is becoming increasingly more common. Nevertheless, there are some obvious risks of operating in a more authoritative and direct legal system, but the rewards are almost always, believe it or not, those legal standards work in your favor. The Chinese system often allows for greater evidentiary advantages for IP owners than the U.S. And I can tell you this from personal experience. We had a few years ago a case where we were working with an industrial design. And we had no question that we could get this industrial design registered in the US and in Europe. We potentially had an invalidating reference in China. That is, someone had actually used it in a way in China that would have prohibited, or otherwise, had it been in the US, for example, it would have prevented us from getting industrial design protection in the US. Working with Chinese counsel, excuse me, working with Chinese counsel, we found that the invalidating reference standard was much different, to the point where we could actually go to the Chinese tribunal, admit that there had been this invalidating reference, and then demand that the other side produce the information about that invalidating reference. And without their ability to do it, there would be no problem with the registration. That is completely the opposite of the rule in the U.S. Not only would we have been required to produce that reference on our own, but we would have also had to basically admit that our own case had been invalidated. You can imagine the CYA letters and the confirmations that we had to send to Chinese counsel. It was all confirmed and the case went through. So this is an amazing result, and it's a result that would only have been available in China. So that's another reason you might want to consider the advantages. Let's take a look at Europe. They have much more cost-effective centralized enforcement. Relatively fast, inexpensive, centralized European enforcement has become more expensive, but not as prohibitive as in the U.S. When I say more expensive, you might have been looking at 70,000 to 80,000 euros. The 2010s, maybe 300,000 euros. Now again, compare this to in the U.S. where we have $2 to $5 million in enforcement costs. This is a very surprising statistic to those who are not familiar with international intellectual property. First thing anyone wants to say when they hear a case is, well, geez, I'm not going to, even if I give protection overseas, I'm never going to be able to enforce it. The numbers are speaking just the opposite. Now, I'm also going to defer to my colleagues and their slides in a minute on the other examples and the clarifications. But this just gives you a flavor of what we're dealing with. Now, I'm going to challenge you with this thought. Available international mechanisms make operating internationally easier and often less expensive than pursuing in the U.S. alone. And by that, I mean that it may, in fact, and often is becoming more often the case, cheaper to pursue in the international arena than in the U.S. alone. I'm going to give you a couple of examples of some of the systems that I work under directly. The Patent Cooperation Treaty, PCT, that's pretty much the bread and butter of my practice, is a system that allows for a single international patent application which can be filed instead of an initial U.S. application, or in addition to. And it keeps most industrial countries available for possible protection for 2.5 years, 30 months. 12 plus 12 plus 6, 2.5 years is 30 months. That can equal major cost savings for a variety of reasons. There are other systems that are also available for transnational any European country, period, and not limited to the EU. And there are similar systems in Eurasia, primarily the former states of the Soviet Union, some of the Russian Federation states, and also there are 2 systems in Africa. And these systems allow you to even draw it out even further. So you could use the PCT system to delay the decision where you're going to get intellectual property, patent protection specifically, by 30 months, and then you can use these other systems to even push up the decision even later. Again, major cost system, the savings. Now, one of the things I would really like to emphasize in having this presentation is that even though we're talking about a legal update in intellectual property is just an example of internationalization. There are systems in virtually any business area that are making internationalization easier and more cost-effective than operating in the U.S. alone. Okay, some examples in the legal area would obviously relating to trademarks, copyrights, industrial designs, but also for business formations and regulations, product and industrial standards, export, import, other numerous areas. Probably many of you, or if not all of you, are familiar with the CE marks, which are for the European Union, minimum standards that they have for commercial products and available consumer products. There's a similar mark in China. These are kind of akin or analogous in some ways to like our UL marks or other industrial standards we have here. But I think it's clear that the trend internationally is these systems, these networks and mechanisms are becoming more and more available. So much so that they're actually, it's making entering the international market actually a specific example of how we can use the U.S. system, the international system compared to the U.S. system to specifically use a European and a Chinese patent registration to improve your ability to enforce in the U.S. So we're actually going to use our international registrations to improve our ability to enforce our patent right here in our country, in the U.S. So here's a simple reality and a simple strategy. Okay, we're going to start with assuming that we've successfully secured a patent in China, and I'm going to just assume that patent has been enforced by the Chinese authorities. Okay, we're going to assume that we've spent possibly a few tens of thousands of dollars in doing that. Now, we've also secured a patent in the European Patent Office. It's enforced by the European authorities. And maybe a few hundreds of thousands of dollars doing that. So we have a patent we've secured in China, a patent we've secured in Europe. Now we're going to look at our U.S. patent in the U.S. And the question is, will our U.S. patent be enforced? Well, I'm going to challenge you with the thought that perhaps your Chinese and your European patents are effective tools in enforcing the U.S. And how is that? Well, your competitor, the infringer, already knows that your patents have been successfully enforced in Europe and in China. They also know that they're looking at possibly $2 to $5 million or more legal expenses. Now, they've already spent quite a bit of money defending. A patent owner has already been been that successful abroad. Do you really want to take the risk in the U.S. as well? You can use your foreign patents as a way to leverage your U.S. intellectual property rights. This can also be done in a variety of different ways. I can go on for hours. But I think you really need to remember that when you have a portfolio of intellectual property protection around the world, you're looking at potential investors who are going to be seeing, well, maybe they can invest in your technology and they know that they have a potential to sell it around the world, not just in the U.S. There are so many different ways that you can use your foreign patents to your advantage. Sometimes people will pose to me the thought, well, if we go to Europe, isn't the European Patent Office, their system, less effective than it was? I mean, we have Brexit, right? You know that the European Patent Office is actually broader and more encompassing than the European Union. There are several countries of Europe, in Europe, for example, Iceland, Switzerland, Norway, some of the Eastern European states that are not members of the European Union, and soon it'll be Britain, but all of them are members of the European Patent Organization. I was at a conference back in March at the University of Akron, which has a big symposium every year for intellectual property. It's probably the best attended symposium in the country. And there was a major announcement, and then it was met with major applause by patent practitioners from around the U.S. Well, ever since the Brexit vote, those plans have been sidelined, and so it looks like we're going to revert back to the European Patent Organization. The EPO has proven itself to be a very effective option for patent applicants. I think you're going to see more in some of the slides from my colleagues' examples that even though we will have slight hiccups here and there like Brexit, the overall trend abroad is for increases in international mechanisms for both intellectual property and for other areas of business. That's the basic message that we're making today. And if you need any more information, please just ask me. There's my contact information. But I'd like to introduce, and unfortunately they can't be here today, my colleagues who helped me with the past presentation that we did last month, Mr. Christian Menges and Dr. Frank Shore of the deal partner firm in Munich. And I'm going to go through these slides a little more quickly just because there's a lot of them, but keep in mind when you look at these numbers, you may see slight variations from the numbers on my earlier slides, but anyone who studies statistics will know that when you have large distributions, large numbers that are of about the same order of magnitude, you start seeing these numbers move in the same directions. Those are more specific. Those are more reliable statistics. I mean, if these numbers were exactly the same as the ones that I was coming up with, coming from different sources, I'd be a lot more skeptical with the legitimacy of them. But they're surprisingly consistent. Now, they made Christian and Frank made only IP that is valuable to an IP owner is enforceable. Enforcement of IP in the U.S. is very expensive and time-consuming. Everyone acts in a global market. And obtaining intellectual property abroad, plus in the U.S., is more expensive than one single patent only. That's true, although it's becoming less the case anymore. However, having IP rights abroad pays off as it opens the door to comparatively cheap and fast lawsuits. That was a point that they came up with on their own independently of our firm. We actually met with when we met to confer before giving the presentation. We were surprised that this result was shared because not all attorneys that practice in intellectual property, especially those that are not in the international arena, quite see it that way yet. Now, some of these numbers, and keep in mind the numbers that we offered before were to give you a flavor. Here's some more specifics. In the U.S., you're looking for the lawsuit. That's the cost. When he says the cost of first instance, he's talking about the initial lawsuit, not necessarily the appeals. So this is when we're in the federal courts in the U.S. You're looking at $2 to $5 million probably in litigation costs. 24 to 36 months. That's not till the ultimate enforcement. That's just at the first instance. So that's two to 3 years just beginning. The loser does not pay, and the court in the U.S. that has the most cases every year is the Delaware federal courts. Well, that's not surprising because that's where all of the corporations are. In China, the minimum costs are $14,000 to $45,000, maybe 12 months, and the loser pays if the loser's an infringer. Although with the lower cost, it's not quite the incentive to avoid court like in the U.S. So the Beijing IP court has 1,263 cases. I'm not sure actually what the only symbolic qualifies as, but the Paris courts are the greatest enforcers in France. Germany, 45,000 to 250,000, 6 to 13 months. The loser pays, yes, and there's a statutory cap apparently, and Dusseldorf happens to be their court of greatest enforcement. In the Netherlands, it's surprising that in the Netherlands, it's a relatively smaller country compared to the big three, the UK, France, and Germany. I mean the big three in the European Patent Organization. They have a surprisingly expensive system for the first instance. Good reason why in my firm, we usually advise our clients if they really can't figure out where to get their protection in Europe under the European Patent Office. We usually tell them think about the UK, France, and Germany because they're the three largest economies in the European Patent Organization system. You're looking at 10 to 20 months. The loser pays, yes, and The Hague is their most active court. In the UK is extremely expensive, 66,000 to 2 million. But keep in mind, 66,000 level is probably going to be on the low end. 2 million is on the way up on the high end, and we're still lower than the minimum costs in the U.S. So even in an extremely expensive jurisdiction, the costs are low. Looking at about 1.5 years for the court for the first instance. The loser does pay. Those familiar with American law will know in the U.S. we have the American rule where everybody pays for their own lawyer. In Britain, the British rule is that the loser pays, so it's a little bit different. There's a little slightly greater motivation for one side to prevail because of that. And then, of course, London is the most active court by different courts. There's no jury, no discovery. The plaintiff may apply for evidence preservation or evidence investigation and collection conducted by the court. The IP court typically appoints technical investigators assisting the judges. Preliminary injunctions are available. Courts order the infringer to pay reasonable costs to the claimant. However, there is generally no need for the plaintiff to reimburse costs to the defendant. Of course, if we have lower costs, it's not as big of a deal. And the court fees are calculated according to statutory proportion of the monetary value of the case disputed by the parties. Now, these numbers they're giving, the low levels of complexity are 14,000 to 28,000 US dollars. Average 45,000 to 170,000. Remember, our low numbers are 2 million in the U.S. So these are statistics. And I was actually surprised that these numbers worked out this well. You saw a point again to these numbers that I presented earlier. You know, the large flavor, the generalizations are surprisingly consistent. This is just some statistics about the number of cases. I guess Beijing, Shanghai, and Guangzhou are the most active courts. I was really surprised that Guangzhou was the most active of all of them. Interestingly, other Chinese courts have little experience. And one thing that probably was properly pointed out by the gentleman from the U.S. Council in China when he visited our task force was that it really does depend on the province. That's probably why you have some areas that where you only have a 66% enforcement rate. That is, a lot of that has to do with the relative expediency of the Chinese system in general. But I think the fact that you have such a high success rate among intellectual property owners in China in such a system, I think it's not much if you're a foreign applicant or foreign IP owner coming into China. Other than maybe the inherent delays you might have from waiting for electronic mail to get to the day after. I do a lot of work in China with Chinese clients, and it's the one aspect of my practice that keeps me up until 2 or 3 in the morning every night. They're 12 hours ahead of us, so our 2 or 3 in the morning is 2 or 3 in the afternoon for them. Let's now take a look at France. Validity and infringement are handled by the same court. No jury, no discovery. Extensive measures for preserving evidence. Cannot be refused if a valid patent is an issue in the case. Judges tend to have little experience in IP and no technical experience. Preliminary injunctions available but rarely used. Recoverable costs awarded by the winning party. Typically between 5,000 and 16,000, no court fees. So you see some of the variations they have just nationally. But I'd also like to challenge on the thought that in the U.S., most U.S. judges have very little technical experience. Unless you are using one of the tribunals that are now available at the U.S. Patent Office. With the American Invents Act, a lot of the grant review that happens actually happens by tribunals within the patent office. That's a little bit different than it was even a couple of years ago. But when you do finally wind up in the federal courts, it's very unlikely you're going to have a federal judge that happens to have an engineering degree or a science degree right in the technical field of what you're dealing with. So I would say that this is not an unusual situation in most countries. Now again, it identifies the Court of Paris that handles the most cases. Interestingly, they don't use expert opinions as much, even 18 to 20 months for the first instance. Now, I want to caution you, don't jump to the conclusion to think, well, okay, in Europe I don't have to worry about experts. Because in Germany, the situation is quite a bit different. In validity actions, judges are engineers, infringers, judges have more technical experience, they're handled by different courts. The case are handled by different courts. No jury, no discovery, that's definitely a cost saver. There are measures for preserving evidence, the so-called anti-PA orders, and parties respect quality of the decisions. Preliminary injunctions are available, border seizures available, loser pays up to a statutory cap, and court fees are recoverable. Attorney's fees are calculated based on the value of interest. What's interesting on this chart, you're looking at some of the values of the interest. They calculate the cost is going to be more keyed to the actual value of the amount of controversy, which is surprising for US. We don't really see that in the US as much. But look, even the cost risk, their high is way lower than our minimums. So again, you're seeing this trend that being in the international arena really is resulting in a cost savings. And here's some more statistics. Let's see how we're doing on time. Litigation in the Netherlands. Surprisingly, for a relatively small country, now Netherlands isn't as small as you might think. I believe they're, after the big three, France, Germany, and the UK, I believe that the next next largest EPO jurisdiction is going to be Spain, Italy, and the Netherlands, I believe. So it's not that small. But nevertheless, they are pretty high costs. But even the high costs are much lower than the US. And I would again challenge you. I don't think you're going to see companies litigating in every single country in the world. We're going to start to see how expensive it starts to get. Again, the court that handles in The Hague. Rare requests for technical experience because the judges in the Netherlands have technical experience. The average duration of the first instance, even there, the high numbers for normal procedures still lower than the minimums in the US. Litigation in the UK, infringement, invalidity, all handled by the same court. There's no jury. Discovery is not available for proceedings. The intellectual property enterprise court. That's where damages are below $660,000. So they're operating a little bit differently than we would, because it's hard to see where patent infringement cases for such a low level would even exist in the U.S. Again, another reason why you might want to go abroad. Judges are experienced in intellectual property, so they may not have the same level of technical experience, but they definitely have a little bit in intellectual property. Recoverable costs are determined by judges on an issue-by-issue approach. Value-based court fees, which again is something we don't see in the U.S., but they're pegged here specifically. And then courts that use them in England and Wales. Frequent use of expert evidence, experiment-based evidence, and 18 months is the duration of the 1.5 years. I don't have statistics for Scotland, sorry. So Scotland stays in the UK. I guess we'll have to get a different set of statistics. Now, also, remember, we're talking about patents in a lot of these instances. I spoke about industrial design a minute ago. There's a lot of different areas of intellectual property which protect the ornamental design of a functional item. Ornamental designs can include jewelry, furniture, beverage containers. Everybody see a Coke can? The Coke can, believe it or not, is a subject of industrial design patent in the U.S. In addition to the trademarks that you see on it, just the shape of the can, and also the shape of the bottle. And then, of course, trademarks. Everyone knows trademark. What's the most famous trademark? Probably Coca-Cola. But any recognizable sign, design, expression which identifies products or services of a particular source from those of others. Very first day of law school that I took trademarks 101, the professor doesn't even say good morning. He sits at the podium and he says, trademarks are indications of source. Sits down. I wanted us to absorb that fact, because that's so important. It's something that's missed on a trademark. They are not inventions. They are indications of source. And there are multinational treaties. Now, keep in mind, this is all evidence and an example of the internationalization of this area of business. Of this one little slice, not only of law, but of intellectual property, it's highly internationalized. Utility patents are covered by the Paris Convention. Anybody have an idea how long the Paris Convention's been around? You know, it's been around since, I believe it's like 1896, I believe is the date. Over 100 years anyway. The Patent Cooperation Treaty, which I practice under, it's an existing international framework. I believe it was entered in the 1970s. It didn't really get widespread use until the 1990s. Now, there are practices like mine that practice almost exclusively under the PCT. The European Patent Convention is just for Europe. And as I mentioned before, it's probably going to be the major European system that's a agreement. It's very similar to the PCT for utility patents. And there's a European community design. One thing that is very effective is if you have an industrial design, a design patent, it's very inexpensive to get coverage in Europe. Just because it's actually less expensive to go to in many cases, to go to the European community design than it is to go to, let's say, the Danish office directly. We very frequently are asked by our clients, well, we know it's very inexpensive to go to the European Intellectual Property Office to get this design patent protected. Might it even be cheaper for you to go to the national office? We usually advise our clients don't even bother, but if they want us to look into it, we do. And normally it's more expensive to go to the national offices. If you get a registration in the European Intellectual Property Office for an industrial design, it covers the entire continent. Well, this is probably one exception, because you will most likely see the UK withdrawing from the agreement for industrial designs. So we're probably going to see an increase in the number of filings in the UK office directly. Trademarks are covered by an agreement called the Madrid Protocol. They call it the Madrid Agreement and Protocol concerning the international registration of marks, and then a European Union trademark. European Union trademark, we usually will defer to our foreign counsel on that. My practice, we usually don't use the Madrid Protocol, and the reason for trademarks, because there's actually a slight disadvantage to U.S. applicants. That may be changing soon. Once it does, that's going to be another system that's going to be available, and it'll make the cost of getting trademark registrations much less overall. Use it as it doesn't have the worldwide acceptance. If you look at the map here, the green countries are the ones that use the Hague Agreement. The U.S. is only a recent signer to that agreement. So you've got pretty good protection throughout Europe and the U.S., but some of the big ones, China, India, Brazil, Australia, even Canada. A lot of these countries don't use the Hague Agreement yet. And on top of that, if you do use it, the goods and services description that you would get with your trademark registration tends to be much narrower than what you would be entitled to in the U.S. So we don't use it, but that may be changing. And I mentioned the community design of the EU. That they're talking about the industrial design system they have. Protection throughout Europe. The only exception being Switzerland, Switzerland and the non-European Union members, Iceland, Norway, some of the Baltic states. It's the one exception where we're going to lose a member because with Brexit, the UK will be coming out. Now, the Patent Cooperation Treaty, this is again the area that I practice on under the most. Compare this to the Hague Agreement you saw a minute ago. You've got protection in all of the major industrial countries. One exception used to be India. That has changed. Now the big exception is Argentina, and also if you want to get protection in Taiwan, you cannot get protection there through the PCT. You actually have to go through a different system. Our Chinese counsel, interestingly, handles the cases for Taiwan for us. So they're still working out an agreement, make it so that we can get protection there as well. But Argentina is pretty much the only major industrial country with most effective systems out there. And I wish I had more time because I'd go into a lot of details on it. They gave a cost of $4,000. It really varies dramatically by the level of your technology, the intensity of your technology. The European Patent Convention is another system. I mentioned that, I touched on that earlier. Now again, they didn't put Great Britain or the United Kingdom in green because they are not leaving the European Patent Convention system at all. The EPO will be around. I mean, you don't see countries like Norway, Iceland, the Baltic states are even green. Even Morocco's in green. Does anybody know why? In fact, I would probably be inclined to add some of the European, even the former Soviet states in the near future. The reason is even if a country, a European country, Turkey is not a member of the European Union, they're part of it. Even if a European country is not specifically in the European Union, or even not specifically a member of the European Patent Convention, they will most likely accept a European registration as their own if you just pay a supplemental fee. So, by far, the most effective frameworks for protecting international IP, especially patents, are going to be will be the PCT system plus the European patent system. And then the international patenting strategy. What was most surprising when I spoke with my colleagues is that they have a strategy that's very similar to the one that we were proposing for our clients here in the US. And I think this just demonstrates that when you have a practice that is truly international in its focus, you're going to be looking at some of the same strategic points. Now, what we usually tell in our practice is develop the easiest way to do that. Start with US provisional applications and then just go straight to international applications. That's the most cost-effective way to do it. Then don't be afraid to enforce international. Now their bullets are the first application, the filing is in the US. And again, they suggest one or more provisional applications, just like our practice does. 12 months later, the priority offered by the Paris Convention, a PCT application, according to the Patent Cooperation Treaty, is filed in order to reserve rights in essentially all countries in the world. 18 months later, that's the PCT system's deadline, national and regional phases are filed in the desired countries, including one example. They took this example from us, the Chinese and the European patent offices. But I'll tell you, I would say that the vast majority of our clients that go international and that are on a tight budget, they usually go to the US, to China, or at least to one of the major Asian markets, and then to Europe because they know they can do one filing. And that usually represents the bulk of their international portfolio. 12 months later, the US patent is eventually granted. 24 months later, the European patent is eventually granted. That number is a strong approximation, but again, this is just a flavor. And then 5 years later, the first infringer appears on the horizon, and then at that point, you would go back to the example with the red boxes I just showed a minute ago. So, in conclusion, let me just say this. I think I've shown that at least in this narrow sliver of business that I operate in, as an owner of an intellectual property law firm, we're finding that internationalization represents major cost savings. This is not an exception. This is the way business is turning. I think everyone at this conference has the word keep in mind, I originally fashioned part of this presentation aimed at an audience members that were operating in a business climate that has been hurt significantly by international competition. Nevertheless, the word international is not something that we can run from. It is a concept that we must run to full speed ahead. Businesses must become international, or international will come and get them. I want to wish everybody a lot of luck in their inventing, in developing their international business, and operating in the international arena. And so thank you very much, and I will take questions now. We have a question in the back.
Yeah, I understand your reason for wanting to use the form
personally, now keep in mind, I'm not a patent litigator, but I certainly have operated in many circumstances, either in the support role or in various capacities in enforcement. My personal opinion is it doesn't really matter, because unless you have a pure contingency arrangement with your counsel, most likely it's going to, the costs are going to be about this. I mean, they're going to be comparable whether you're bringing the case or you're defending it, with some major exceptions. I'm sure if I had a litigator standing here right next to me, he'd probably be holding his head saying, no, John, no, John. But from what I've seen, it really doesn't matter. Now, people will say to me, what if I get a lawyer to do it on a contingency? Contingencies are there to realize. I mean, what's the first thing that someone says when they dealt with a lawyer in any court? Well, I sued somebody, I won, but the lawyer got most of it. Well, no, the lawyer didn't get most of it. The lawyer most likely had you cover the lawyer's cost, and the lawyer took anywhere from a third to a half of what the winnings were. That's not the lawyer getting most of it. That's the lawyer getting paid for not only that case, but also for all the cases the lawyer lost. Remember, contingencies are not guaranteed. So I don't think it really matters as much whether you're bringing the case or you're defending the case. I think what it matters is you're seeing a lot of resolution happening in the international arena that you can use to leverage your situation in the U.S. where the costs are ultimately higher.
I have apologies, maybe I missed word here.
Sure.
If you're wanting to, go over there, right? Wouldn't, as a value to it, you're starting here because of their costs and defendant being so high. There's a value to that.
No, actually, the costs here are no matter what level you're dealing at, the costs in the U.S. are likely going to be much higher, and it's not going to be just the cost to file it. And maybe not even the discovery and the interrogatories and the depositions and all that stuff that you're paying your lawyer hundreds of dollars an hour to do. It's also going to be just the fact that the courts tend to be a lot more efficient time-wise. I mean, China, as I mentioned, is lightning fast. Part of that is because their system is much more oriented toward the first instance than it is in the U.S. In the U.S., the district courts, federal courts may issue a verdict in the case. Either side then will go to the appeals courts, and when IP practitioners like myself are trying to figure out what the law is, we're going to be reading decisions not from the courts of first instance, but from the appeals. Other countries, I think China is probably the best example. The appellate system is almost a formality. I mean, that goes on every level. I mean, from their criminal system to their civil system. Unfortunately, I don't have my Chinese colleagues with me here, but they would certainly agree with that. I mean, they are much more focused on the first instance than we are in this country. Yes?
So you have to file your patent in the U.S. and the PCT and all of the different locations?
Yeah, that's an excellent question. Well, see, that's an excellent question. That's kind of the point we were hoping to get to a little bit. In my practice, I mean, historically the practice was that an applicant would file a U.S. application, and it may or may not be a provisional, would file a U.S. application, and then under the PCT system would eventually file a PCT and then go have a separate U.S. application pending, and a separate PCT application pending, and then moving on the world. We don't do that in my firm in most cases, because the PCT application can also be the basis for a U.S. patent as well. What we normally do is we advise our clients to file, we call it the Whitlaw approach, to file numerous provisional applications. When I first started practicing, I started practicing roughly on Y2K. So it's been about 16 years. I was in other capacities practicing before that, but I began my first law job basically on Y2K. During that, when we first started, we were operating under a different system. The U.S. adopted what they call the American Invents Act in 2013. It came online in March 2013. Maybe some of you are aware of the first. Because of these changes, this new Whitlaw approach that we've developed suggests that you should file lots of provisional applications. Really, if you have a new invention, you should be filing a new provisional application maybe at least once a month, or at least as often as you have any kind of development at all, because the provisional application won't hurt you. Provisional applications were developed in the U.S. specifically to facilitate international filing. That's why we have provisional applications. Not necessarily why we use them, but that's why that was a specific intent, was to file provisionals which are easily prepared. We used to prepare the provisional applications as exactly the way our non-provisional, our formal application was going to look. So we would be spending all kinds of money right at the beginning for putting a very elaborate formal application together, and then we would just add claims to it and file it as non-provisional 1 year later. Now, under this new first to file regime that we have under the American Invents Act, you're much better off to file several provisionals over the course of the year. Get those provisionals pending, and then when you get close to the deadline to file your non-provisional application, put them all into a non-provisional format. But we, in our firm, we don't file a U.S. application. Your provisional application can be the basis under the Paris Convention for a PCT application. So you take your group of provisional applications, and you file one international application. So for the cost of preparing one application, one filing fee, you now have potential protection on that map. Every area in green on that map, for paying one fee, you have possible protection.
So
We never had the provisional system the way that we did. The reason was they've always, at least in the foreseeable past, have had a first-to-file system. And because they had the first-to-file system, there was no reason for them to have provisionals. Again, there's a misunderstanding by most applicants in the U.S. The provisional applications are not supposed to be crude applications where they throw a bunch of information and just get it going. That's what they've become, because there's no requirement that you include claims. They actually withdrew the claims requirement for non-provisional applications in the U.S. back in 2013. I don't know if most applicants aren't aware of that either. But they've never had to have the provisional system because they've never had to deal with the first-to-file system. Or, sorry, first-to-event system like we have here. They've always had the first-to-file system. So I would say that an American applicant is actually at a considerable advantage because we can put together a provisional, and then we can follow it up with a PCT. American applicants are also an advantage because U.S. applications tend to be much longer and much more thorough and give wider, broader protection than cases that come from abroad. I do a lot of cases that come in from foreign clients, and some of them are very well written, but a lot of them are, once you get past the broken English and you get them transferred into a U.S. format, the next thing that becomes apparent is that they really don't put the breadth of care into it. So it's just an inherent advantage that American applicants have. So any other questions? Or?
So if you're a U.S. company, and how do you convince your U.S. company? Do you have examples of companies that?
Okay, first of all, I'm going to just give one example. Before I started Whitlaw a couple of years ago, I worked for a large company. I'm sorry, for a large law firm, and it was one of our largest clients. And I had probably as early as 2001 or 2002, I had been when I went to law school. I was at I spent 1 year at a special program that was populated mostly by international students, and they had a huge emphasis on the PCT system. And I'd never heard of it, even when I'd taken my Patents 101 course and had been a law clerk before that. And I was intrigued by this PCT system. And it was, even though it wasn't all that new, it was considered a new thing, just because it was starting to be utilized heavily. Well, when I started practicing law, it really wasn't even being used by the big firm yet. And I stressed, I pleaded with one of our largest clients, you guys really need to start filing internationally, or at least considering going international. And the response that I got was, well, our product is mostly steel, it's very heavy, it's hard to export it abroad. We don't really see ourselves trying to protect it overseas. That reflected the fact they didn't really understand what a patent was, but nevertheless, that was their reasoning, and they said, we don't think we're going to go international. Okay, that was their first thought. By the time I left my last firm and started my own firm, they were our single largest international client because they were more or less forced into it. Now, they were forced into it dragging and screaming, but eventually they started to see it our way and realized the importance of it, and it was really a make it or break it. Probably because they started having international customers that wanted their product badly. The international customers. This is probably one of the best examples that I can come up with. If you were to go over my client, through my list of clients over the last 16 plus years, going on 17 years that I've been practicing, you could draw a line right down the middle of the clients. The clients that did pursue international protection, the clients that did not pursue international protection. I cannot think of a single example where the clients that did not pursue the international protection are still in business. And I can't think of any examples of companies that did pursue international protection that are no longer in business. So it's amazing how important this is. It's almost like a simple recipe. Pursue internationally, and your company does well. Ignore it and pretend it doesn't exist, and you falter. You know, I can't back that up with any statistics from the government or from any agencies. I'm just going by my own practice. But we were operating in a Rust Belt region. Both our Erie and Cincinnati offices are located in cities where there is a large amount of tool and die and manufacturing. And the companies that went international, they're in business. The ones that didn't, they're gone. Sir.
I know that the utility of the model is and protect for the patent you use in Europe and China.
You're talking about industrial designs?
I mean the utility.
For everyone to take advantage